Good day, everyone. This is Arugo Speaks on Arugo Insights. Today, we'll look at romantic promises and legal intent. As a continuation of our series on intention to create legal relations, we'll be analyzing the breach of promise suit of Doris Ogala against Pastor Okafor in the light of the Supreme Court decision in Ezeanah and Atta, by way of introduction. Here at Arugo Insights, we have long maintained the steadfast policy of refraining from delving into personal affairs of individuals in the public eye, including but not limited to Nollywood celebrities, pastors, politicians, and other prominent figures. This approach stems from a commitment to focusing on broader legal, social, and policy issues that foster informed discourse and respect for privacy. We believe that personal matters, particularly those involving relationships and domestic arrangements, are best handled privately and should not be subject to unnecessary public scrutiny unless they intersect with significant legal principles or policy interest concerns. However, in the light of the numerous questions and feedback messages we have received from our valued followers, we have decided to make a thoughtful exception in this instance. Many of you have reached out expressing a desire for us to address the alleged failed romance between Ms. Doris Ogala and Pastor Okafor, as well as her reported pursuit of justice for claims including the breach of promise to marry. We appreciate your engagement and trust in our platform, and it is precisely because of this community-driven interest that we are providing this brief legal analysis. Please note that our commentary is not intended to pass judgment on the individuals involved or to sensationalize the matter. Instead, it aims to objectively examine the potential for success in such a claim, particularly against the well-established legal backdrop that social and domestic relations are generally not intended to carry binding legal consequences. This principle, rooted in the common law traditions and Nigerian jurisprudence, emphasizes that agreements in personal relationships often lack the requisite intent to create enforceable obligations. We will explore these aspects with utmost professionalism, drawing on relevant legal precedent to offer clarity and insight for our audience. Thank you for your continued support and understanding as we navigate this topic responsibly. The failed romance, or the alleged failed romance, between the Nollywood actress Doris Ogala and the celebrity TV pastor Okafor revolves around her public allegation that the Lagos-based cleric repeatedly promised to marry her over the course of their relationship or alleged relationship. According to Ms. Doris Ogala, these assurances led her to make significant personal sacrifices, including divorcing her previous husband and transferring control of a bank account containing 45 million to him. She further alleged that he introduced her to his family early in the relationship, reinforcing the seriousness of his intentions, only to later abandon her and marry another woman, resulting in severe emotional distress, health complications, and reputational damage. The scenario directly engages the common law doctrine of intention to create legal relations, a fundamental requirement for the formation of an enforceable contract. Let us delve into the legal analysis. In domestic or social contexts, such as romantic relationships, there is a long-standing presumption that parties do not intend the agreements to be legally binding, as illustrated in the English case of Balfour and Balfour. I go back to our lecture on intention. You will understand how we dissected these principles, starting from Balfour and Balfour to Spellman and Spellman, Jones and Padervatin, and then we got to Merit and Merit, Madrigal and Madrigal, and we got to the finality of those principles. However, the Nigerian law, which retains the English common law principles, treats promises to marry as a notable exception where the evidence demonstrates a clear mutual intention to enter legal institution of marriage rather than mere romantic expressions. The presumption can be rebutted. The Nigerian Supreme Court in Ms. Ezeanah and the Alhaji Mahmood Atta, a 2004 decision, emphasized that for a promise to marry to be enforceable, the agreement must leave no doubt as to the intention of the parties to marry, and such intent may be inferred from the conduct of the parties even in the absence of a written agreement. You know that it is rare to write an agreement that, hey, we will marry. And so the court, in my view, is right to say that the intention for marriage will be inferred from the conduct of the parties. The Supreme Court case, in that Supreme Court case, the appellant, Ms. Ezeanah, and the respondent, Alhaji Mahmood Atta, were involved in a romantic relationship during the 90s. The respondent, who played the dominant role in the relationship, bestowed numerous gifts on the appellant, including fully sponsoring her further studies in England in 1994, renting an apartment for her, and frequently visiting her in London from Nigeria. The court dispute centered on the ownership of plot 999 in the cadastral zone B6, Mabuchi district, Abuja. That's the heart of Abuja. The respondent asserted that he had procured and allocated the property to the appellant in contemplation of their intended marriage. He further claimed that the appellant had breached the promise to marry him by ending the relationship, thereby entitling him to recover the property, potentially on the basis of a resulting trust or revocation of a conditional gift. In contrast, the appellant, Ms. Ezeanah, claimed that she was the absolute and rightful owner of the property. During the trial at the High Court, judgment was delivered in favor of the appellant, with the court finding insufficient evidence to establish either a binding agreement to marry or a resulting trust contingent upon marriage. Upon appeal to the Court of Appeal partially addressed or modified aspects of the decision of the High Court, prompting the appellant to appeal the case to the Supreme Court. The Supreme Court ultimately affirmed the ownership of the appellant and dismissed the claims of the respondent in their entirety. The Supreme Court underscored that the respondent had failed to adduce sufficient evidence to prove the existence of a clear and mutual agreement to marry, or that the property was held on trust condition upon the marriage taking place. The Supreme Court took the opportunity to clarify the legal principles governing breach of promise to marry. He held that while such promises remain enforceable in Nigeria, unlike in England, where the action was abolished in 1970, the agreement must leave no doubt as to the parties' genuine intent to enter into marriage. Mere romantic affection, casual relationships, or sweet nothings are insufficient to ground an actionable claim. Evidence of intent may, in appropriate circumstances, be inferred from the conduct of the parties even without a written agreement. But no such clear evidence existed in this case. This decision has become a leading authority in the requirement for proving breach of promise to marry, namely 1, a clear mutual promise extending beyond casual romance, and 2, an unjustified breach resulting in detriment to the innocent party. The Supreme Court decision in Ezeanah and Atta has established itself as a leading authority in Nigerian jurisprudence on the essential requirements for establishing a claim of breach of promise to marry. The case outlined, as earlier stated, 2 fundamental elements that must be proven. 1, the existence of a clear and mutual promise to enter into a statutory, customary, or Islamic marriage extending beyond mere romantic affection or casual expressions. And 2, an unjustified refusal or failure by one party to fulfill that promise. Additionally, the Supreme Court has clarified that the intention to marry may be inferred from the conduct of the parties even in the absence of a written agreement, provided it leaves no doubt as to their serious and genuine commitment. Although Ezeanah and Atta is widely cited and extensively discussed in legal commentaries, academic articles, and professional blog analysis as the modern foundational pronouncement on this subject, there appear to be few, if any, widely reported appellate decisions after 2004 that directly cite and apply it in subsequent breach of promise to marry litigation. If there is any case, we have not seen it. If you have seen it, let us know. This scarcity in publicly accessible records may be attributable to the fact that many such disputes are resolved through out-of-court settlements handled primarily in lower courts such as the high courts or magistrate courts without formal reporting or dismissed at preliminary stages due to evidentiary shortcomings. Nevertheless, the principles enunciated in Ezeanah and Atta continue to be applied and affirmed in related matrimonial causes and contractual disputes involving conditional gifts or promises contingent on marriage. Lower courts routinely require plaintiffs to meet the Ezeanah criteria set by the Supreme Court, including the provision of corroborative evidence beyond mere sweet nothings and demonstration of detrimental reliance. The decision is also approvingly referenced in analysis of cases dealing with gifts made in contemplation of marriage, reinforcing the position that ordinary romantic relationships do not, without clear mutual intent, give rise to enforceable obligations. Earlier precedent, such as Egbe and Adefarasin, decided in 1987, which affirmed the general actionability of breach of promise to marry, are frequently discussed alongside Ezeanah, but post-2004 judicial practice has adopted the more stringent evidentiary threshold set by the Supreme Court in Ezeanah and Atta to distinguish binding promises from casual romance. The pre-2004 case of Uso and Iketu Bosun, often cited in discussions as landmark where damages were awarded for breach after a long engagement, illustrates the application of similar principles though it predates Ezeanah. In contemporary practice, ladies and gentlemen, Nigerian courts persistently uphold breach of promise claims within the framework established by Ezeanah and Atta, giving damages for proven financial, emotional, or reputational losses where the required elements are satisfied, while often moderating or rejecting exaggerated claims. Let us apply the principle in Ezeanah to the facts as told by Doris Ogala. In the present case of Doris Ogala, the allegations of repeated promises, family introductions, and her detrimental reliance, divorcing her former husband and handing over substantial funds could arguably rebut the presumption against legal intent. These actions suggest that the assurances of Pastor Chris Okafor may have transcended casual romantic rhetoric and created an implied intention to form a legally binding commitment. If proven, the law is clear: he who asserts the existence of a thing must prove that that thing does exist. So if proven, this would transform the promise into an enforceable contract. That's a humble opinion, potentially giving rise to liability for breach and associated damages under principles of promissory estoppel or direct contractual remedy. Doris Ogala has consequently, or is rumored to have filed a 1 billion naira civil claim against Pastor Chris Okafor, seeking damages for breach of promise to marry, emotional distress, and making a claim for a public apology, amongst other reliefs. Let us state it: in Nigeria, unlike England, where such actions were abolished in 1970, breach of promise to marry remains an actionable civil wrong. To succeed, Doris Ogala must establish a clear and mutual promise to marry. Again, she must also establish an unjustified breach by the pastor, and then she would also establish quantifiable losses flowing from that breach. Publicly available details, such as her claims of financial transfers and life-altering decisions made in reliance on his promise, provide some evidential foundation for these elements. That said, the suit's ultimate merit of the suit remains uncertain and would depend heavily on the quantum of evidence or quality of evidence presented in court, including communications, witness testimony, and documentation of alleged promises and reliance. The requested, let me just state this on a very casual note. The requested 1 billion appears substantially inflated when compared to awards in similar Nigerian cases, which typically compensate actual expenses and modest emotional harm rather than punitive or exemplary sums. Take note of this, please. Additionally, prior public disputes between the parties, including earlier accusations by Ogala of indebtedness and calls for investigation into the church of Pastor Chris Okafor, may, in our humble view, be portrayed by the defense as evidence of ulterior motives, potentially undermining her credibility. On a concluding note, while the lawsuit of Doris Ogala is not frivolous in any form and could plausibly proceed to trial or settlement on the strength of the law in Nigeria in recognition of breach of promise to marry actions, full success, we would say, particularly at the claimed quantum, is far from guaranteed. The case illustrates the rare but significant intersection between romantic commitments and legal accountability when the doctrine of intention to create legal relations is satisfied through clear evidence of mutual intent. Ladies and gentlemen, thank you for listening to us. Please visit our YouTube channel, Arugo Insights, and subscribe. And then go to our other social media platforms, Instagram, TikTok, Facebook, and Twitter, and follow us. We are doing this for you, and we are here to respond to your request for further elaboration on this topic, if that is what you want. Thank you. Appreciate it.
Arugo Insights, the show that shines the light.